The Supreme Court of Canada just rolled up the national sleeve and injected an extremely harmful substance into our judicial arm. The immediate effect was confusion, but over the long run we must fear chronic constitutional weakness. The confusion appeared first. In a typical response, BC MLA Jenny Kwan, who's from Vancouver Mount Pleasant NDP, said the ruling sends a very strong message to Stephen Harper: ideology must not trump science. And the Canadian Medical Association, one of 10 interveners in the case, welcomed the court's unanimous ruling because, the president said, while for some this is an ideological issue, for physicians it's about the autonomy to make medical decisions based on evidence, and the evidence shows that supervised injection reduces the spread of infectious diseases and the incidence of overdose and death. Hardened drug warriors may be tempted to react indignantly that the evidence shows the opposite, but not so fast. What should arouse indignation is that this ruling was plainly not judicial in nature, precisely because it supposedly turned on scientific evidence. The issue before the court, because it's a court, had nothing to do with whether safe injection sites are good public policy. It was, when a provincial law says one thing and a federal law says another, which should prevail on legal and constitutional grounds, not whether either law or both were silly, ideological, or just plain mean. Normally, such a question would turn on whether the matter was provincial, federal, or shared under Canada's Constitution, and also whether one or both laws violated the Charter of Rights. The Insite case was a bit more complicated, involving also whether provincial jurisdiction over health allowed an exemption to federal criminal law. The court had little trouble settling the jurisdictional question and upholding the federal criminal justice power over the provincial health one. It even upheld the law banning various drugs. But then it ruled that the Minister of Health, by not using his fully legal power to grant an exemption, had violated drug addicts' right to fundamental justice by making a dumb choice. Obviously, they didn't phrase it like that, but it is what they said. And if they meant it, we have a charter right not to have politicians make dumb policy choices, as the Supreme Court defines dumb policy. The funny thing is, the justices can't really think our Constitution says that. How then did they come to assert it in a precedent-setting case? Apparently, they succumbed to the great temptation behind judicial activism, to work backward from the outcome we want to something resembling legal principles that let us have it. In this case, they declared that scientific evidence about effective harm prevention determined whether a minister's exercise of his lawful authority infringed the right to fundamental justice. This wears legal clothing, but inside is a policy judgment. To determine what constitutes fundamental justice, we should look to books of law and political philosophy, not chemistry texts, and ask whether everyone is equal before a law and are all subject to transparent and timely procedures uncontaminated by bribery, fraud, or intimidation, not whether something in a test tube turned blue. I'm not saying the federal government was wise to refuse Insite and exemption. I am merely saying it had the legal power to do it, and the court clearly should have said so. In fact, in case you're wondering, I'm not upset by the ruling because I support the war on drugs. I don't. I think the whole business is unwise, unsound, and immoral. But that's not the point. Indeed, the whole point in discussing a court decision is that policy isn't the point. Law is. This was not a parliamentary debate on policy matters. It was a court case. And the job of the Supreme Court is not to decide cases based on what I think the law and Constitution should say. It's to decide cases based on what the law and Constitution actually do say. And that clearly means it is also not the job of the court to decide cases based on what they think the law and Constitution ought to say. I know members of the Supreme Court show little doubt of their capacity to discard the traditional judicial habit of working from known, stable legal principles and instead make wise policy on a case-by-case basis. As constitutional expert Richard Moon noted in his book on freedom of expression in Canada, the court has a distinct habit of starting with a traditional John Locke kind of assessment of the right of free speech and finding that a challenged law infringes that right, then switching to a sociological analysis of privilege and discourse clearly incompatible with the principles it had just been applying and upholding the law anyway. It may seem all like fun and games up on the bench, but it weakens our constitutional order because other courts are very liable to follow cosmic precedents in cosmic ways, and there's no legislative check on their authority. Thus, the judge's decision to adjourn to the laboratory in the Insite ruling could well lead to a charter challenge, not only of other drug restrictions, but of things like prostitution laws, and it won't matter what citizens think. It makes me especially uneasy that the Supreme Court, due to the dog's breakfast Trudeau made of our Constitution, is now a branch subject to no sort of check or balance. It's an alarming invitation to abuse power with the best of motives. And this is unmistakably what the court has just done. Not even they know where it will lead. If the Supreme Court did not see this coming, it underlines how far they've drifted from any genuine understanding of what law is and how it works. which is the last thing you'd expect or desire from people in their job. Now, the justices may think if they decide things have gone too far, they can pull another judicial rabbit from their wigs, saying, well, this precedent doesn't really mean what it seems to. Remember what happened with the Marshall Eels case. And they'll trust that that bunny won't get loose and breed either. But it will. These rabbits always do. Even the soberly progressive Globe and Mail explained that the Insite ruling gave judges a new tool for activism and ensured that legal waves would surge across several important Charter of Rights cases already in the courts and spawn many new challenges. The result of this kind of haphazard jurisprudence is that you never know where you stand. I wouldn't even want to be a lawyer trying to argue a case before such a court. I certainly don't enjoy being a citizen trying to create good public policy when any law we manage to pass can so easily be dropped into this legal blender. It's not just confusing when judges play mad scientist. It dramatically weakens our constitutional system of self-government. This was not a safe injection.